Here is the number that should scare you more than the knock on your door. In the United States, a single ignored piece of paper, one sheet, one signature, one deadline you decided didn't apply to you, can legally end with a federal marshal placing handcuffs on your wrists before you've finished your morning coffee. Not because you committed a crime, not because you did anything wrong in the first place, just because you didn't show up. And here's the detail that makes it worse. Some witnesses who have refused to comply with the subpoena, particularly in federal grand jury proceedings, have been held in civil contempt confinement for periods stretching over a year, not sentenced, not convicted of anything, simply held indefinitely until they decided to cooperate or until the legal proceeding itself expired. No trial, no jury, no fixed release date carved in stone, just a locked door and a decision entirely in your own hands about how long you're willing to stay behind it. Welcome to Catastrophe Theory, where we figure out exactly how fast your life falls apart if you actually let the intrusive thoughts win. I'm CJ Theory, and today we're looking at what happens when you decide just once, just this one time, that you're simply not going to answer that subpoena sitting on your kitchen counter. Let's begin. You are standing in your hallway. It's 7:14 in the morning, and there is a manila envelope on the floor, half slid under your door, the way pizza flyers get pushed through door gaps, except this one has your full legal name printed on the front, along with a case number and a seal you don't recognize but instinctively understand is not friendly. Your hands are still damp from the shower. The paper feels heavier than paper should feel. Thick cardstock, crisp corners, the kind of document engineered to communicate authority just from its texture. You read the first line. You are commanded to appear. Not requested, not invited, commanded. There's a particular silence that falls over a room in that moment. The refrigerator hum gets louder. Your own breathing becomes audible to you, like your body is trying to remind you that you're still technically in control of something. You think about your calendar. You think about your job, your kids, the vacation you already paid for. You think, just for a second, just as an intrusive thought, the kind this channel is built to explore, what if I just don't go? Let's stay in that hallway for one more moment, because the details matter. You notice, almost absurdly, that your feet are cold on the hardwood. You notice the envelope has been folded once deliberately so it would fit through the gap under your door. Someone stood on the other side of that door recently, close enough to hear your television, close enough to see the light under the frame, and chose not to knock. That's a small, specific kind of unease, the awareness that a legal process has already touched your physical space before you were even aware it existed. You flip the envelope over. There's a return address for a county courthouse you've driven past 100 times without ever once imagining your own name would end up filed inside it. You think about calling in sick to deal with this later. You think about just not opening it further, setting it on the counter, letting today be a normal day. The coffee maker beeps. Somewhere in your chest, a small, quiet, deeply human voice says, maybe if I just wait a few days, this will sort itself out. That voice is not stupid, and it is not rare. It is in fact one of the most common first reactions recorded among people who later find themselves facing contempt proceedings. Not defiance, just delay, dressed up as a coping mechanism. I've spent years talking to attorneys, former court officers, and people who have actually lived through the aftermath of that exact thought. And I want to be honest with you before we go further. This isn't a video designed to terrify you into paranoia. It's designed to do the opposite. Fear untreated becomes catastrophe. Fear understood becomes preparation. So let's take that intrusive thought seriously, walk it all the way down its worst possible staircase, and see exactly where it ends. Because here's the quiet human truth underneath all of this. Almost nobody who ignores a subpoena does it out of malice. They do it out of fear, disorganization, denial, or the simple, universal, deeply relatable belief that if you don't look at the problem might forget you exist. It won't. And understanding why it won't is the first step towards never having to find out the hard way. So what actually is this piece of paper, mechanically speaking? Let's treat it like an engineer would treat a bridge, not with dread, but with respect for the forces involved. A subpoena, at its core, is not a suggestion, an invitation, or even technically a punishment. It's a court order disguised as a letter. The word itself comes from Latin, subpoena, literally under penalty. That phrase is doing enormous quiet work. It means the penalty isn't a separate future possibility. It's baked into the document's DNA from the moment it's issued. You are not being asked whether you'd like to participate in the justice system. You are being informed that you already are participating, whether your calendar agrees or not. There are two main species of this document, and understanding the difference matters more than most people realize. A subpoena ad testificandum commands a person to appear and testify, to physically show up and speak under oath about what they know. A subpoena Duces Tecum commands a person to produce documents, records, or objects, bank statements, emails, physical evidence, whatever the court believes is relevant. Either way, the underlying mechanism is identical. A court which holds the legal authority to compel testimony and evidence in the name of a functioning justice system has extended that authority into your specific life on a specific date for a specific reason. Think of the American legal system as an enormous, invisible machine that runs on information. Trials, grand juries, civil disputes, criminal investigations, none of it works if people can simply decline to participate whenever it's inconvenient. So the system built in a pressure valve, a way to say your participation is not optional, because the alternative is a justice system that only works for people who feel like showing up. The subpoena is that pressure valve. It's the mechanism that keeps the entire structure from collapsing into voluntary chaos. Picture the brain for a second as a kind of internal security guard, constantly scanning incoming information and deciding what deserves a fight-or-flight response and what can be filed away as background noise. Most paperwork in your life gets filed as background noise almost instantly: a bill, a flyer, a reminder about a dentist appointment. A subpoena is specifically engineered through its formal language, its official seal, and its explicit reference to legal penalty to bypass that filing system entirely and get flagged as urgent. That's not an accident of bureaucratic design. It's the entire point. The document is built to be impossible to casually misfile in your own head as something optional, precisely because the system needs your internal security guard to treat it with the seriousness it deserves. And this is where the analogy becomes useful for understanding enforcement too. Just as your brain's security guard doesn't personally hold a grudge against the junk mail it filters out, the judge enforcing a subpoena isn't operating from anger or personal offense when you fail to appear. The judge is simply the human embodiment of that same filtering system, scaled up to the level of an entire institution, deciding, case by case, whether an absence represents a legitimate obstacle or a decision to simply opt out of a system that isn't built to allow opting out. Here's a hook worth sitting with for a moment. What do you think actually happens in the eyes of the law the instant you decide to ignore it? Is it treated as a rude decision, a missed appointment, or is it treated as something closer to defying the court itself, in person, to its face? We're about to find out, and the answer is less like a missed appointment and a lot more like a lit fuse. Let's walk through the actual chronology, the anatomy of this event, part by part, the way it unfolds in the real world rather than in your panic of your imagination. Part 1. The moment of non-compliance. The court date arrives. You don't show. You don't call. You don't send a lawyer in your place. From the perspective of the issuing court, this is registered instantly and unambiguously. There is no gray area here, no maybe they're stuck in traffic grace period built into the system's threshold for concern. If you were required to be present and you are not present, the absence itself becomes a new, separate event with its own legal weight, distinct from whatever the original case was about. This is the part almost nobody understands intuitively, and it's worth repeating slowly. Your failure to appear can become its own legal problem, independent of the original matter. You could have been called as a completely innocent witness in a case that has nothing to do with you personally, and yet failing to show up transforms you, procedurally, from an innocent bystander into someone now facing consequences of your own making. Part 2. The motion. The party who subpoenaed you, whether that's a prosecutor, a defense attorney, opposing counsel in a civil suit, or a grand jury, notices your absence and generally files what's called a motion to compel, or in more serious situations, moves directly for a finding of contempt. Think of the judge in this moment as a kind of security guard standing at the door of an important room. Their job isn't necessarily personal, they're not offended that you skipped out, but their entire function, the reason the position exists, is to make sure that when the system says you must be here, being here is not optional. When you don't show, the guard doesn't shrug, the guard escalates. Part 3. The contempt finding. This is where the word nightmare starts to earn its place in this video's title. A judge has the authority to hold you in contempt of court for disobeying a subpoena, and contempt comes in two flavors, both worth understanding because they behave completely differently. Civil contempt is designed to be coercive. Its entire purpose is to pressure you into finally complying. It often comes with the phrase, "You hold the keys to your own cell," because in many jurisdictions, once you comply, once you show up, once you hand over the documents, the contempt sanction can be lifted. Criminal contempt, on the other hand, is punitive. It exists to punish the defiance itself, and it doesn't necessarily go away just because you eventually cooperate. It's the difference between a door that unlocks once you finish the task and a fine that's already been permanently assessed regardless of what you do next. It helps to hold on to a concrete image for the difference between these two forms of contempt. Civil contempt behaves like a locked door with the key sitting in your own pocket the entire time. Uncomfortable, restrictive, unmistakably real, but structurally designed with an exit you control by complying. Criminal contempt behaves more like a sentence already handed down, a closed chapter rather than an open negotiation, existing specifically to express that the court's authority was defied, and that defiance itself carries a cost independent of whatever you do next. Judges generally reach for civil contempt first because coercion is the gentler tool, and reserve criminal contempt for situations where defiance has been particularly deliberate, repeated, or damaging to the proceeding itself. Part 4. The warrant. If contempt escalates far enough, particularly in criminal proceedings or grand jury matters, courts can issue what's sometimes called a body attachment or a bench warrant, a legal instrument that authorizes law enforcement to physically locate you and bring you before the court. This is the part your nervous system was waiting for in that hallway scenario. This is the marshal, the knock, the handcuffs. It is rare. It is not automatic, but it exists fully loaded as the mechanical endpoint of sustained non-compliance, and it exists precisely because the system needs an answer for the person who decides that ignoring paper forever is a viable long-term strategy. Worth noting, a bench warrant issued for failure to appear doesn't announce itself immediately. Unlike the dramatic, instant escalation you might picture from television, these warrants often sit quietly in a database, unexecuted, until an unrelated interaction with law enforcement, a broken taillight, a routine identification check, brings it to the surface. That delay isn't mercy. It's simply how overburdened systems process volume. The warrant doesn't go away in the meantime. It waits. Part 5, and this is the part almost nobody talks about, the collateral damage. Fines can range from modest to genuinely life-altering depending on jurisdiction and the nature of the case, sometimes accruing daily until compliance. Jail time for contempt, while less common for an ordinary witness than popular television suggests, is a real documented outcome, particularly in grand jury contexts where witnesses have been held for extended periods specifically because they refused to testify or produce evidence. And underneath all of that sits something quieter and more corrosive: your credibility. If you're ever a party to litigation yourself, a documented history of evading legal process can be used against you, painted as evidence of evasiveness or bad faith, coloring how a judge or jury perceives everything else you say. Part 6. The special case of the grand jury. Most subpoenas exist inside a case that already has a visible structure, a plaintiff, a defendant, a trial date on a calendar somewhere. Grand jury subpoenas are different, and they're worth understanding on their own, because they produce some of the most dramatic and most misunderstood outcomes in the entire system. A grand jury is a body convened, often in secret, to determine whether enough evidence exists to bring charges in the first place. Because its proceedings are confidential, a witness subpoenaed to testify before one is placed in a strange, high-pressure position, compelled to appear, sometimes compelled to answer questions under a grant of immunity that removes their ability to refuse on self-incrimination grounds, and bound by secrecy rules about what happens inside that room. Witnesses who refuse to testify even under immunity have, in documented cases, been held in a specific category of confinement called civil contempt confinement, not a punishment for a crime, but a coercive measure meant to pressure testimony out of them, sometimes lasting for the length of the grand jury's term, which in some jurisdictions can stretch to 18 months. Think about that for a moment. Not 18 months for committing a crime, 18 months potentially, simply for the ongoing choice not to speak. There's a quieter form of collateral damage worth naming too, one that rarely makes it into the dramatic retellings. Employers, in many cases, are legally required to allow employees time off to comply with a valid subpoena, but that legal protection doesn't erase the awkward conversation you now have to have with your manager, the shifts that need covering, the explanation you owe coworkers who notice you're suddenly gone for a day. None of that is catastrophic on its own, but it's part of the honest, unglamorous cost of the situation, and pretending the only stakes are jail or nothing undersells just how disruptive even a fully compliant response can feel in the middle of an ordinary week. That disruption, uncomfortable as it is still an entirely different category of problem than the one waiting at the end of continued avoidance. It's also worth being precise about something that varies quite a bit depending on where you live. The exact mechanics of contempt, the available defenses, and the severity of penalties differ from state to state and differ again between state courts and federal courts. Federal contempt proceedings, particularly those tied to grand juries, tend to carry the heaviest and most durable consequences, partly because federal grand jury terms can run so long. State civil matters, by contrast, often resolved with fines or short-term coercive detention that ends the moment compliance happens. This isn't a detail meant to comfort you into thinking it probably won't be that bad. It's a detail meant to underline that the actual severity of your specific nightmare depends heavily on the specific court, the specific case, and the specific jurisdiction, which is exactly why generic reassurance from a stranger on the internet is never a substitute for a real conversation with a licensed attorney familiar with your situation. Here's a question worth sitting with, a small cliffhanger inside the mechanics. If contempt of court is designed to be coercive rather than purely punitive, why do people still end up in jail for months at a time over it? The answer lives in a legal concept that surprises almost everyone, and we're going to unpack it properly in a moment once we've cleared away the myths standing in the way of understanding it. Because that's the next problem, and it's arguably a bigger one than the mechanics themselves. Most of what people believe about subpoenas is not just slightly off, it's actively dangerous, the kind of misunderstanding that turns a manageable situation into a genuine catastrophe. So let's do some myth-busting, the kind that could actually save someone's future. Myth number 1. A subpoena is just a request, and I can politely decline if I have a good reason. Reality, a subpoena is a court order, not a request, and declining it unilaterally is not a recognized legal option, no matter how good your reason feels to you personally. Why it's false? The entire design of the subpoena exists specifically to remove the opt-out button that a request would normally have. If you have a legitimate reason you cannot appear, illness, scheduling conflict, financial hardship in producing documents, a legal privilege that protects certain information, the correct path is to file a motion to quash or modify the subpoena or to negotiate with the issuing party through an attorney before the deadline. The system has a formal appeals process built in. Silent non-appearance is not it. Silence in this context is not neutral. It's read as defiance because the machine has no mechanism to distinguish too busy from refusing. Myth number 2. If I just avoid being served, the subpoena never legally applies to me. Reality, many jurisdictions allow for alternative or substitute service, leaving documents with an adult at your residence, mailing them to your last known address, or in persistent evasion cases, allowing a judge to authorize other creative service methods entirely. Why it's false? This belief treats service like a video game mechanic, as if standing in the wrong hitbox at the wrong moment makes you immune to consequences. Courts anticipated this exact strategy decades ago, precisely because people have always tried it, and built procedural workarounds specifically so that evasion doesn't function as a permanent shield. Dodging the process server doesn't dodge the process. It usually just adds evasion to the growing list of behaviors a judge will remember unfavorably later. Myth number 3. Only criminal subpoenas are actually serious. Civil ones are basically optional. Reality, civil subpoenas carry the same contempt of court exposure as criminal ones. Why it's false? The seriousness of a subpoena comes from the fact that a court issued it, not from the category of case it belongs to. A civil litigation subpoena for financial records ignored persistently enough can absolutely result in fines, adverse rulings against you in the case, or contempt sanctions. The "it's just a civil matter" instinct is one of the most dangerous myths on this list, precisely because it feels so reasonable in the moment, and reasonable feeling mistakes are the ones people actually make. Myth number 4. If I ignore it long enough, everyone involved will eventually just move on and forget. Reality, court systems maintain records, and outstanding warrants or contempt findings do not expire quietly with time the way a forgotten email might. Why it's false? This myth borrows logic from social situations, the awkward text you never replied to, the group chat that fades. But legal systems are built on documentation with permanence in mind. A bench warrant sitting quietly for years doesn't dissolve on its own. It can resurface at the worst possible moment: a routine traffic stop, a background check for a new job, an attempt to renew a passport, and detonate a problem you'd convinced yourself no longer existed. Myth number 5. I don't need a lawyer for something as simple as a subpoena. I'll just show up and explain myself. Reality, even a completely innocent witness can inadvertently create legal exposure for themselves through poorly worded testimony, incomplete document production, or accidentally waiving a legal privilege they didn't know they had. Why it's false? This myth assumes that the danger in a subpoena situation comes only from non-compliance, when in reality, mishandled compliance can be almost as damaging. Attorneys aren't there to help you dodge your legal obligation. They're there to make sure that when you fulfill it, you do so in a way that doesn't accidentally expose you to a separate problem you never saw coming. The cost of a single consultation is almost always smaller than the cost of learning this lesson after the fact. Notice the pattern underneath all 5 of these myths. Every single one of them is built on the comforting idea that inaction or uninformed action is a neutral, low-risk choice. It never is. Inaction in the presence of a legal order is itself an action, one with its own name, its own procedural pathway, and its own consequences. That reframe alone is worth the entire video. There's a common thread running through every attorney I've spoken with about this topic, and it's worth pausing on before we move to the checklist. Almost none of them describe their clients' original mistakes as sinister. They describe them as understandable. A single parent who couldn't figure out childcare for the court date and simply froze. A small business owner who genuinely believed the case had nothing to do with him and set the envelope aside, meaning to deal with it next week. A young person, served for the very first time in their life, who had absolutely no framework for what any of this meant and let embarrassment keep them from calling anyone for help. None of these people set out to defy a court. They simply let a solvable problem sit long enough that it stopped being solvable through ordinary means. That's the emotional core worth carrying into the next section. This isn't about becoming the kind of person who never makes mistakes. It's about becoming the kind of person who, when the mistake is still small and fixable, actually reaches for the fix instead of the avoidance. So now let's turn fear into agency, because that's the actual point of this channel. If you or someone you love ever finds that manila envelope on the floor, here is the concrete, actionable checklist, the thing worth saving, screenshotting, sending to a group chat. Number 1. Read the entire document immediately, calmly, and in full. Don't skim it in a panic and set it aside for later. Note the date, the time, the location, and exactly what's being requested of you: testimony, documents, or both. Read it twice. Panic makes people skip the sentence that actually mattered. Number 2. Identify who issued it and for which case. Subpoenas typically come from an attorney, a court clerk, or a grand jury, and knowing which one changes your available options significantly. A subpoena tied to someone else's civil dispute over a contract is a very different animal than one tied to a criminal grand jury investigation, and your response should reflect that difference. Number 3. Contact an attorney before the deadline, not after. Even a single consultation can clarify whether you have valid grounds to object, whether the subpoena was properly served, or whether portions of what's being asked for are protected by privilege, attorney-client communications, certain medical records, or other categories of legally shielded information. Many attorneys offer brief initial consultations specifically for moments like this. Number 4. If you genuinely cannot comply on the given date, file the correct paperwork, typically a motion to quash, a motion to modify, or a formal request for extension, rather than simply not appearing. The system has a front door for legitimate objections. Use it instead of the back exit. Judges generally respond to formal, timely objections with far more patience than they respond to silence. Number 5. Communicate, always in writing, with the issuing party or their attorney if there is any conflict or confusion. Phone calls are easy to forget or deny ever happened. A written record, an email, a formal letter, creates the kind of documented good faith trail that looks completely different to a judge than silence does. Number 6. Never destroy, alter, or hide documents you've been asked to produce, even ones that feel embarrassing or damaging. That single decision transforms a manageable compliance problem into a potential obstruction of justice charge, which exists in a defined, far more serious category of legal exposure than the original subpoena ever carried. Number 7. If you receive a subpoena for someone else's case and you're worried about self-incrimination, understand that you retain constitutional protections, including the ability to assert your Fifth Amendment rights on specific questions. But that assertion happens in the room, in front of the court, through your attorney, not through simply staying home and hoping the question never comes up. Number 8. Keep a copy of everything: the original subpoena, any correspondence, any filings, any proof of mailing or service, in a single organized place, physical or digital. If this situation ever escalates, your own paper trail becomes your strongest piece of protective evidence. The difference between "I tried to resolve this" and "there's no record you tried anything at all." Number 9. If you've already missed a deadline, don't compound the mistake by continuing to avoid it. Contact an attorney immediately and address it head-on. Courts generally respond far more favorably to someone who shows up late with a genuine explanation and a plan to comply than to someone who continues disappearing. Number 10. Treat every court communication, no matter how minor it seems, as something deserving your full, immediate attention. A postcard-sized notice can carry the same procedural weight as a thick legal filing. The system rewards responsiveness and punishes silence far more harshly than most people expect, until they've lived through it themselves. Number 11. If the subpoena requests something you believe is genuinely irrelevant to the case, resist the urge to simply decide that on your own and ignore the request. Relevance objections are real and legitimate, but they're resolved by filing a formal objection and letting a judge make that determination, not by unilaterally deciding you know better than the court what the case actually needs. Save that list, send it to someone. The version of you standing in a hallway at 7:14 in the morning, heart pounding, staring at an envelope, is not the version of you equipped to think clearly. The version of you watching this video right now, calm, curious, slightly unsettled, but still in control, is exactly the version who should be making these decisions in advance. Let's zoom out now, because I promised you at the start of this channel that we don't just leave you in the fear, we walk you through it and out the other side. Here's the reframe. A subpoena and the entire apparatus of contempt and enforcement standing behind it isn't actually a trap built to catch ordinary people doing ordinary things. It's closer to a load-bearing wall in a building you walk through every single day without noticing it's there. You don't think about the justice system's ability to compel testimony when you're going about your Tuesday. You don't think about the machinery that makes contracts enforceable, that makes witnesses reliable, that makes courts something other than theater. But that invisible wall is exactly what allows the rest of the structure, your rights, your protections, the ability to seek justice when you personally need it, to stand upright at all. The fear you might feel imagining that hallway scenario is not irrational, and I want to validate that plainly, without hedging. It's a reasonable nervous system response to the idea of institutional power intersecting with your one small personal life. But fear, left unexamined, calcifies into avoidance, and avoidance is precisely the behavior that turns a manageable legal obligation into the exact catastrophe we walked through in Act 2. The people who actually end up facing warrants and contempt findings are rarely calculating criminals. Overwhelmingly, they're people who froze, people who let a very human, very understandable moment of denial metastasize into months of escalating consequence simply because looking directly at the problem felt harder than looking away from it. Now, here's the quiet philosophical center of this whole video. The justice system, for all its cold formality, its Latin phrases, and its stern envelopes, is fundamentally a machine built on the assumption that people will show up. That assumption is not a trap set for you. It's a kind of dry procedural trust, a wager that the system makes on your behalf, betting that when it's your turn to matter, someone else will show up too. The subpoena is the mechanism that keeps that wager honest for everyone, including eventually you, on the day the system needs to work in your favor instead of someone else's. Understanding that doesn't eliminate the discomfort of ever receiving one, but it does something more useful than eliminating discomfort. It replaces panic with procedure. It turns a moment that could spiral into catastrophe into a moment that simply requires 3 phone calls, 1 attorney, and a calendar entry. That's the entire difference between the nightmare version of this story and the boring, forgettable version where you just showed up, said your piece, and went home to make dinner like it was any other Tuesday. There's something almost humbling in that comparison if you sit with it long enough. We tend to imagine the justice system as something enormous and impersonal, a machine indifferent to the particular texture of our individual Tuesdays. And in a sense, that's true. The system doesn't know or care that you have a dentist appointment, or that your kid has a recital, or that the timing is, from where you're standing, catastrophically inconvenient. But that same indifference is exactly what makes the system trustworthy in the moments that matter most. A justice system that bent around everyone's individual inconvenience would, by definition, be a justice system that couldn't be relied upon by anyone, including the version of you who might one day desperately need a witness to show up on your behalf, a document to be produced on time, a court to actually mean what it says. Consider for a moment the alternate universe where subpoenas really were optional, where the intrusive thought at the center of this video was actually a safe one to act on. In that universe, testimony would only ever never come from people who felt like giving it. Evidence would only surface when it was convenient for whoever possessed it. Trials would become negotiations not over truth, but over who could afford to simply wait the process out. The subpoena, unglamorous and unwelcome as it is on a random Tuesday morning, is one of the load-bearing walls that keeps that alternate universe from becoming the one we actually live in.
And that, honestly, is the quiet miracle hiding underneath all of this. The most ordinary parts of your life, paying your taxes without incident, renewing your license without a hitch, walking past a courthouse without your pulse spiking, those are not accidents. They're the visible calm sitting on top of an enormous, mostly invisible machine, one built specifically so you never have to think about it, until for one strange morning you do. Go back for a moment to that hallway. The cold floor, the envelope, the coffee maker beeping in the background like nothing in the world has changed. Now imagine a slightly different version of that same person standing in that exact same hallway holding that exact same envelope, except this version has watched this video. This version doesn't feel the floor drop out from under them. They feel something closer to recognition. Oh, this is that thing. I know what this is. I know what happens if I ignore it, and I know exactly what happens if I don't. That shift from dread to recognition is the entire emotional distance this video was built to cross. It's worth saying plainly one more time because it's easy to let the mechanics of contempt and warrants overshadow the actual point. The overwhelming majority of people who receive a subpoena and respond to it appropriately never experience anything resembling the nightmare scenario at all. They show up, they say what they know or hand over what they have, and they go back to their lives within a day, sometimes within an hour. The catastrophe isn't hiding inside the subpoena itself, it's hiding inside the space between receiving it and responding to it, the gap where fear, denial, and avoidance are allowed to grow unchecked. Close that gap quickly with the right information and the right professional help,